Ma'am, what's your name?
Me?
Yes.
I'm
Yes.
Christine. Yes, I'm Christine McWayne. Mine is at 2 o'clock. Do you want me to remove my video or audio?
Oh, you're fine. I just need to name your device so I know who it is.
Okay, this is Christine McWayne.
Ms. Julie, the 130 did not appear.
Very well. Thank you, Your Honor.
Thank you. Okay, Mr. Kirschenheiter, you're here on the matter with Christine McWayne.
Yes, Judge.
Okay, on the record, in the matter of American Express National Bank versus Christine McWayne, file number 23010666 GCE. Counsel, have your appearance for the record, please.
Michael Kirschenheiter for the plaintiff, P75722. How are you?
I'm doing well. How are you?
Not too bad.
Very good. And then, ma'am, Ms. McWayne, state your name for the record, please.
I'm Christine McWayne.
Okay, today was the date and the time that was set for a motion, I'm sorry, for an objection to an installment payment order. And Ms. McWayne, you did file a motion for installment payment order. There was a judgment in the amount of $8,571.75. You're indicating that you would like to make installment payments of $100 per month that would have started on June 1st. That's correct?
That is correct.
You say your average income is $270 a week.
If that.
Are you working full time?
I try to, but they have cut my hours and they replaced me with people that have been that are the superiority that have been hired after me. I fight to have my hours back, and they don't give that to me. It's a very toxic work environment right now.
Okay. And the only look, you put a vehicle 2019 Nissan Kicks with the amount that you owe. You say you have no money in the bank. You don't pay any rent, utilities, or other bills.
No, I just food, basically food, gas, my car payment. And that car I was forced to buy because I totaled my previous car when I was working 4 jobs and fell asleep.
Okay. Okay, and then counsel, I read your response. Your position is it will take 8 years to pay that in full at $100 a month, correct?
Yeah, basically, Judge, it just take a long time, but obviously I understand the circumstances as well. So however the court wants to proceed.
Okay, so I recognize as well that it's not ideal for the payments to be in the amount of $100 per month, but she's only bringing in about 270 a week at this time. The court will grant her request and deny the objection. However, I will set it for a 6-month review and she can give us an update on her financial status.
Sounds
Yes.
good.
Yes, please. As I'm trying to look for a new job, and as I search, I'm looking for something that will actually give me a better income and a way to move up the ladder. Right now, it's just dead end, and I would like to increase my payments if I can with a better job and more income to sustain myself.
Okay, it sounds good. I wish you luck in that. I'm sure that you can find other employment. It doesn't sound like this location is really giving you much. So I will note here again that it's granted. I'm assuming you did not make a payment on June 1st, correct?
I've just been garnished. I have not made any payments. And even I just actually last Friday, I received a letter that I was garnished to my last penny from my account, which was an accrual of $5 that I have in there to keep my account open.
Hold on. Off the record. Sorry. Okay. I'll note here, $100 payment will be made monthly. And we'll begin that starting July.
Wow. I do have a question about that. How do I make a payment? Because I don't have a bank account. And all I would get, like right now, I'm just, if what I earn, I get cash for, and I do pop cans and stuff like that, but how do I make a cash payment? Is there a money order or a way to do that? Because I don't even know how to do that.
Contact.
Counsel, you contact the attorney's office and they'll get that information to you. I was just gonna ask counsel, are the payments made to your office? Is that correct?
Yeah, payments made to my office, a money order's fine. Just contact my office man to discuss your payment arrangements.
Okay, thank you.
Okay, so I'll note that for there, and then this installment payment order will suspend any writ of garnishment. That's not a tax garnishment, of course, okay?
Okay, when is the first payment due?
You said you were garnished when?
I was garnished 11/24 of my bank account for $370, my tax return of $234, and then just last Friday, I received notice that they took my last cent.
Judge, there's been no wage garnishment to date, but we could just start, I mean, honestly, we could start the payments August 1.
Okay, I'll note that the payments will start on August 1st. And you'll, I can put you in a private meeting room with Mr. Kirschenheiter so you can find out how to make payments, okay?
I would appreciate that. Thank you.
Thanks, Judge.
Thank you. Any additional matters for the record?
No.
No.
Thank you. You're off the record. Let's see, Kirschenheiter, I'll put you in room 1. Okay, let's see. This is Mr. Weiss is here on.
Didn't they say they got on base back up?
Is it on?
It's saying it's locked.
Mr. Weiss, you're here on behalf of One Financial?
Yes, One Main Financial, Your Honor.
One Main Financial. Is anyone here for Ashley Long? I don't see Ashley Long.
For the record, Your Honor, is my motion to set aside the dismissal and reinstate. I've been in contact with Ashley Long, now known as Tia Saylor. And apparently she has no objection to it. In fact, she has signed a consent judgment. If the case is reinstated, I would file a consent judgment in this matter.
This is for a general civil matter. Okay, your motion is granted. You can file your paperwork through my file.
Okay, should I prepare an order setting aside the dismissal reinstated and then file my consent judgment, or just a consent judgment?
Yep, we would need the order setting aside the dismissal and then the consent judgment.
Okay, I can file them both at the same time?
Yes.
Okay, thank you very much, Your Honor.
Thank you. Have a good one.
You too. Bethany?
Who are you moving, please? On the record in the matter of South Washington Park versus Corey Blocker, file number 23-02852, council appearance.
Good afternoon, Your Honor. Jeff Klug, appearing on behalf of plaintiff, South Washington Park.
Mr. Blocker is present via Zoom. Mr. Blocker, please remove your hat. Unmute your device and state your name. Unmute your device.
Corey Blocker.
Okay, Mr. Blocker, you filed two motions. I think one is a motion for a motion to collateral attack case. The other is a motion for new trial under Rule 59, but you cite a federal rule, which is this is not a federal court. Mr. Klug, did you get a copy of these motions?
I got a copy of the motion to collateral attack case. I did not get a copy of the other motion for a new trial.
Okay, the motion for new trial, we can have that scanned and sent to you. What email do you want us to send it to?
You can send it to Jeff Klug, so JEFFKLUG at KlugTaxLawFirm.com. So KLUGTAXLawFirm.com.
Scan that to him, please.
You say tax or
That's-
tax?
Scan, I'm sorry, what?
No, it's Jeff Klug at
Oh, his email.
tax or taxlawfirm.com.
Repeat your email again.
I will send, I just sent an email this long.
Okay, and then we can respond to it.
Yeah,
Thank you.
thanks.
I like that. I think my man, I think Sean, Yeah. I'm still looking for that. Right, right, 'cause I'm involved in this talk. Like, oh my God. Oh. They feel it everywhere. This is one of the most violent scenes. Back home, the most violent scene. One of the third most violent scene you can understand. Chicago. Oh, man, don't keep on more violent in Chicago. But you stay right into the hood. We're back home. I love you. Go out here and go back inside. Okay. Right. What's good? Job. I was doing the room down. Oh, yeah. I don't think they probably can do that. Huh? Looks like it. I so sorry. I can do this without. Sure. Sure. What about her?
Mr. Klug, did you receive the email?
Yes, Judge, I'm sorry, I'm just reading it right now. But yes, I
Okay, take your time. Take your time.
Well, Judge, if that's federal rules, I will come back with the Michigan rules because I'm in my year's time limit to make sure I can get a new trial. So I'll bring back and my affidavit of fact.
If you leave, because you did not serve a copy of your motion from the 17th on Mr. Klug, so the court just
Yes,
did you
I
a
did.
courtesy.
Yes,
Well,
I
he
did.
has
I
not,
sat back and
he didn't receive
I
it.
sat back and
You're
mailed.
not
I
gonna
sat back
talk,
and
you
mailed.
will not talk over me. You will not talk over me. If you don't want to proceed today, your motions will be dismissed because of your leaving. If you talk over me, your motions will be dismissed. I will not carry you on in a disruptive manner. You filed the motions, he did not receive them. So we sent him a copy so that he can read them and we can move forward with your motions today.
Okay. Well, collateral attack still works, so no problem.
Okay, whatever that means.
Mm-hmm. This is what I went through when I was in your court locked up illegally. Thought I was getting out of court at the time.
Hey, do you want to be discharged from the courtroom for the rest of the day? Because I'm not going to go back and forth with you in my courtroom.
Uh-huh. I got you. I'm cool. Oh, yeah, and I did file that motion for you to recuse yourself. So I'm filing a verbal motion right now for fraud upon the court because that motion does say I need you to recuse yourself. So I filed a verbal motion right now.
I need you to shut your mouth, and you ain't do that. Yeah. Stop talking out of turn. Stop talking out of turn. When it's your turn to speak, I'll give you an opportunity. Now is not that time.
Gotcha. It's still fraud upon the court.
Judge, I have read that motion, so that I have both of those, the motion to collateral attack and the motion for new trial. I did not receive that third motion he mentioned, nor have I seen a motion filed by him.
There's no third motion in the file. We have two motions, except for two motions today. Okay, so we're on the record in this matter. You've received both motions. The first motion being filed was a motion to collateral attack the case. Mr. Klug, I don't know if you had any argument that you wanted to place on the record as it relates to that motion.
I was just going to do it verbally. I didn't think I needed to submit anything for that.
Right. So at this time.
Okay. So yes, if you want, I didn't know if you wanted Mr. Blocker to go first, if you wanted me just to argue against it.
No, Mr. Blocker has drafted his motion. The court has read it. The essence of the motion for collateral attack is Mr. Blocker believes that there was some fraud committed by the court back on January 3rd, 2024, after the time that we held a bench trial and he was evicted from the premises that he was residing in while he was in the custody of the jail. And he is seeking compensatory and punitive damages in the amount of $25,000. And so the court is, and he's collaterally attacking under the U.S. federal 42 USC 1983. You can proceed to make your argument on that, Mr. Klug.
Your Honor, yes, the plaintiff disagrees with what is stated in the motion. I mean, the court heard evidence, had heard testimony, saw evidence presented, and I did not see any wrongdoing by the court at this hearing. In addition, Mr. Blocker did state, allege that he requested a jury trial. However, the court reviewed the docket and said he didn't file a proper jury request. My assumption is that he didn't actually, as he stated, file a proper jury request and submit the filing fee too at the time, nor did he request that the filing fee be waived. So he didn't properly request a jury trial. The court determination and ruling on that matter was proper. Further, any kind of appeal should have been made within 21 days. This isn't, I don't think this is an appeal, this is a new motion. I thought the judgment was entered on January 3rd. this case should remain closed as it's 100% resolved. I believe that this motion lacks any merit, is factually false and very inaccurate and should be denied altogether. It seems he's requesting relief that this court can't even grant. I never saw a counterclaim or any claim against defendant seeking any damages until this motion.
Okay, thank you. As to the motion for collateral attack, again, the court has read your motion, Mr. Blocker. I'm going to first address your claims in the motion that there was a fraud committed or a violation of your Sixth Amendment right. Your right in a civil matter here in the state district court, because you have seemed to be heavily relying upon some federal rules, which were not in the federal court system. Your rules as it relates to when you can request a jury or demand a jury trial in a civil matter, which we advised you of those rights back on November 29th. So you were in the jail at the time. The court made a writ to get you on Zoom so that you can be advised of your rights at the time of a pretrial. On November 29th, we scheduled your trial on January 3rd. You had over a month at that point to hire counsel if that's what you wanted to do. You were advised of your rights to counsel. You were advised of your rights to have or demand a jury trial. The Michigan Court Rule 2.5089B clearly states a party may demand a trial by jury of an issue at which there is a right to trial by jury by filing a written demand for a jury trial within 28 days after filing of the answer or a timely reply. The demand for jury must be filed as a separate document. You did not do that. The jury fee provided by law must be paid at the time the demand is filed. You also failed to do that. The defendant failed to comply with court rules and failed to file a jury. I'm going to mute you because you're not going to disrupt me while I'm putting something on a clear record here. The defendant failed to comply with the court rule and failed to file a jury demand after filing the answer on a separate document and failed to pay the filing fee at the time of the demand. Therefore, the defendant's jury demand was not granted because it did not comport with the Michigan court rules. In addition, after your hearing or your trial that was on January 3rd, you then filed what the court responded to in a written order on February 20th, explaining why we denied your demand for jury trial because you didn't follow the court rules. You did have a trial, it was not by jury, and you had every right to be represented by an attorney. You appeared without an attorney after having been advised that you had the right to have an attorney, and you were advised of that back in November. You appeared January 3rd without an attorney. You demanded to have the case adjourned. The court rules does not require me to grant that demand to further delay an eviction when you were notified over 30 days in advance that it was going to be set for trial on that date. In addition to that, you knew well before November that you had a pending eviction happening because you had been served with that back in September. I don't have to let you get served with an eviction in September and then hold the case over until you work out your other legal matters and until it's at your convenience to appear in court. You have the right to hire an attorney because you do not have the right to court-appointed counsel in a landlord-tenant matter. You appeared in court, you were disruptive, you brought no evidence, even though you had every right to subpoena or have evidence subpoenaed and brought for you. You did not seek any of that evidence to be brought, and you did not properly prepare for a court. The same way you sat in jail and drafted all of these fine documents and motions that you filed, you could have drafted a subpoena or you could have drafted a request and sent that to Mr. Klug's office to get any evidence that you believe could have helped you support in your defense. The court reviewed the evidence, including a video that showed you kicking a neighbor's door in, and heard testimony evidence of other illegal activities and violations. I think there was almost 30 violations or more while you were in the property that you were residing in. And had you been represented by counsel, and even if you had some additional evidence that you could have presented at the time, the court would have still made the same determination that you had violated your lease and that you had engaged in unlawful activity that created an unreasonable risk of harm and a violation to other tenants' right to have a habitable unit. And so you still would have been evicted whether you had an attorney or not. You also falsely claim in your motion for collateral attack that Judge Simmons was acting under the color of law and in a personal capacity. Judge Simmons is acting in a judicial capacity and not a personal capacity. And for those reasons, your motion for collateral attack are denied, and your request for compensatory and punitive damages in the amount of $24,999.99 are also denied. As to the motion that you filed on the 17th, or at least it was received by the court on the 17th, for a motion for new trial under Rule 59 of the Federal Rules of Civil Procedure, are denied because this is not a federal court. We don't operate under the Federal Rules of Civil Procedure. This is a court under the state of Michigan. You file all your motions to comport with the Michigan court rules and rules of evidence. The courts read and determined that your motion is not only untimely because you were supposed to file any motions or any appeals within 21 days, you did file a motion to stay eviction and a petition to affix a defect, to which the court responded to back on February 20th, indicating why you would not get a motion to stay the eviction, and it's because you did not properly follow the court rules. You still are not properly following the court rules because you've been spending all of your time in the federal rules trying to figure out how you can skirt and navigate the system without being held accountable for violating your lease. Your eviction was finalized and your motions are denied.
Thank you, Judge.
Thank you. Can you present us with an order, Mr. Klug?
Yes, Judge.
Thank you. You're all set.
Thank you. Have a good rest of your week.
Same to you. Mr. Stucroft is here.
Yes, good afternoon, Your Honor.
Good afternoon. You're here for a 2:30 pre-trial against Michelle Lewis. Do you have anybody in the hallway? On the record in the matter of BCG Equities LLC versus Michelle Lewis, file number 24-02256, counsel appearance.
Good afternoon, Your Honor. Attorney Richard Stuckoff appears for the plaintiff, BCG Equities LLC, P85814.
Okay, today was the date that was scheduled for a pretrial for a general civil matter. The matter was scheduled for pretrial at 2:30. It's 2:38. No one's appeared on behalf of Michelle Lewis. Counsel, how do you want to proceed on this?
I would ask that the court find Ms. Lewis in default Plaintiff would supply a judgment order under the 7-day rule. I would also like to note for the record, Ms. Lewis did file an answer stating that she had unforeseen circumstances but admitted to owing to the debt. However, she's stating that she's going through bankruptcy. So more likely than not, this will be discharged once she files her bankruptcy.
Okay, the court will note that on the record and default will enter against Ms. Lewis, and we will request order under the 7-day rule. Any additional matters for today's record?
No, Your Honor. Thank you.
Thank you. You're all set.
Have a great day.
Thank you.